very often when people come to see us for the advertised free consultation that we provide, and it is free, one of the things that is uppermost in their mind is that they know we do bankruptcies, but they really don't want to do a bankruptcy. They're looking for an alternative to it. And of course the alternative that trustees provide is something called a proposal, or more specifically for most people, something called a consumer proposal. And what it does essentially is it allows a person to resolve the financial or debt problem that they have without going bankrupt. And it's done by reaching some kind of a settlement agreement with the creditors through the trustee under the protection of the Bankruptcy and Insolvency Act, the law. And the protection that the law gives is to essentially remove the ordinary options that creditors have to collect their money from you if you're behind in your payments and can't pay them, such as suing you, garnishing you, that kind of stuff, and forcing the creditors to pay attention to whatever offer you want to make to them. And that offer is made through the proposal process. So essentially it works this way. A consumer proposal, a person wants to do that, they're going to figure out what they can afford to pay, because it's usually based on a monthly payment plan. It limits the time period that the proposal can be offered over, in other words, how long it can go. It limits it to 5 years. And the deal that you're trying to make with your creditors is one that is based ultimately on you being able to be out of debt at the end of the day, but you know that the creditors are just not going to accept any old thing you offer, so they're going to want some kind of a reasonable offer to be made. So therefore, you have to be able to calculate very closely, or somewhat closely, what it is you can afford to do. So a proposal as an alternative to a bankruptcy is essentially a matter of figuring out budgets, and then once you know what it is you can offer, then the trustee does the paperwork, the proposal is put together, the proposal is filed, the protection starts, and then everything is turned over to the creditors to let the trustee know whether they're going to accept the offer or not. And if the creditors accept the offer within the given time period that they have, then you have a new deal. So if you came in owing a grand total of $30,000 or $40,000 worth of consumer debts, you might make a proposal offering $15,000 or something like that, and if the creditors see it as in their best interest, they may very well accept that. If they don't, then they may ask for more, and there may be some negotiations that takes place as part of the process, but ultimately, most proposals, some kind of a level can be found between what the debtor offers and what the creditors are willing to accept, so that they can resolve it that way. They can agree. Now, once that's done, and once the creditors have accepted it, then essentially it's up to you, because now the creditors accept it, the court approves it or ratifies it, and then as you're the person who has to come up with the money, so therefore you have to make your monthly payments. The good news on a proposal is that it's an open contract, and you can accelerate those payments. If you could pay more, you can speed it up, and instead of needing the whole 5 years to pay your way out of this debt, you might be able to finish it off in 4 years or 3 years or something like that. Now, all of this is an alternative to a bankruptcy, and the basic difference between a bankruptcy and a proposal is that in the proposal, like I've just described, you essentially make a deal with your creditors. In a bankruptcy, you're not asking the creditors to accept the deal. You're essentially asking the courts to just get rid of the creditors. In other words, to release you from the debts involved. Now, that's a pretty heavy deal, because you've signed contracts, and creditors have a right to expect those contracts to be fulfilled, and the law, the basic laws of contracts are there for a reason, and they're quite valid. But in a case where a person is insolvent and can't pay can't live up to those contracts anymore, then the courts are there to try and find a just resolution to it. Now, when I say the courts are going to release you, what it is that when a person does a bankruptcy, they're asking the courts to, and the word is, discharge them from the debts that they have. There's a process. The person has to go through the process. It can take anywhere from 9 months to 3 years, depending on the circumstances, perhaps even longer sometimes. But for most people, it's a fairly straightforward process. It's a question of just following the administrative rules that are set up, and assuming they haven't done anything nefarious, shall we say, fraudulent or something like that, and most people haven't, then at the end, the courts are going to end up releasing them from their debts. So what you have is on the one side, a trustee offers the resolution of a proposal. On the other side, the trustee offers a resolution of a bankruptcy. Both of them are court supervised, and both of them end up placing the debtor in, let's call it, debt-free land. And they both work.